Lord, we are saying our rights have been, constitutional rights have been violated, and it's only your Lordship that can stop further violation on a momentous issue of impeachment of the Deputy President. My Lord, Sabbatical 3 B gives this Honorable Court jurisdiction to grant an injunction, and C grants this Honorable Court jurisdiction to grant a conservatory order. Nothing could be clearer in black and white in the Constitution itself. So that, my Lord, when this court considers authorities that you be cited by both sides, my Lord, I submit that this court should bear in mind that our transformative Constitution has provided the jurisdiction of this Honorable Court, so that this Honorable Court cannot just factor in decisions from the US, decisions from UK, and decisions from elsewhere, unless it is demonstrated that the constitutions in those countries are in pari materia with our Constitution. In other words, the starting point is our Constitution. Article 2, which your Lordship is aware of, provides for the supremacy of the Constitution and proceeds to say, to provide any other law or any other provision in conflict with the Constitution is null and void to the extent of the inconsistency. So that, my Lord, under Article 25C, Article 25C, the heading of which is fundamental rights and freedoms that may not be limited. One of those rights is the right to a fair trial. That cannot be limited. The people of Kenya thought the right to a fair trial is so fundamental that they said it is not to be limited. What I'm driving to, my Lord, is Article 50, the right to a fair trial. Sabbatical 1 says before a court, or if appropriate, another independent and impartial tribunal or another body. My Lord, it is our submission that the National Assembly, exercising quasi-judicial authority, is constitutionally obligated to ensure a fair trial to the petitioner. And that is a right that cannot be in any manner abridged or limited. My Lord, we say in our notice of motion and in the petition, 1, that the public participation which is required in terms of Article 118 of the Constitution was grossly violated by the National Assembly. My Lord, let me draw the court's attention to Article 118, the heading of which is public access and participation. And B, Sabbatical 1B, says, Parliament shall facilitate public participation. So it's a requirement of the Constitution. An involvement in the legislative and other business of Parliament, other business such as the impeachment of the Deputy President. So, my Lord, if the petitioner is alleging that this public participation, constitutional obligation of the National Assembly was violated, this court has, without any shadow of doubt, the jurisdiction to intervene. My Lord, it is our submission that public participation in this very weighty matter of impeachment of the Deputy President was in this case a sham. It was a show. Totally inadequate in terms of time. The Supreme Court gave guidelines in the British American Tobacco versus the Ministry of Health, and this is in our Battle of Authorities, that public participation must be real. It must have reasonable time. It must be meaningful. Lord, it is on that basis that we are submitting and will be arguing that the 12 days that Standing Order number 64 provided for the entire process of the impeachment in the National Assembly violates Article 50 of the Constitution. The National Assembly had no constitutional authority to limit themselves to only 12 days. That resulted in inadequate public participation on such a weighty matter. But Lord, you will see that first the National Assembly directed that the public participation would be at county headquarters of our 47 counties. The question arises, are the people in any particular county to travel all the way to the county headquarters, one place, to publicly participate, give their views on such a weighty matter? That was on the 4th of October. Lord, when your brother in Kerugoya Court directed that public participation should be at the constituency level, a further notice was issued by Speaker of the National Assembly correctly saying the public participation will be at the constituency level as directed by your brother, Judge in Kerugoya. But that notice, my Lord, was issued on the evening of 4th October. That civic education will be the following day. Where is the time for the people of Kenya to be made aware that there will be public participation the following day? So the public participation, quote and unquote, at the constituency level was on the very date that they had about this further directive by the Speaker. So, my Lord, without going into the details, because you do that during the actual hearing, my Lord, is it any wonder that only 200 and what? The number. My Lord, in volume 2, I think we gave copies to the court. Could you give this to the court here? Page 812. Page 812. The court has the soft copy, but this is a hard copy. If my Lord looks at page 812, you can hand over this. You can hand over this to the court. 812. My Lord has, yeah, hand over. Yeah. Yeah. It is labeled RG11 at the top. Sorry, my Lord. Yes, it did. Who is the owner of it?
He said. No, I want to be sure.
Keep it safe, it's okay.
Yes, you said
Page 812 is actually RG11 in volume 2. If my Lord looks at page 812, left hand corner at the bottom, volume 2. This is volume 2. RG11. But go to 812 of RG11, bottom left hand corner. My Lord, do you see the total number of people who took part in this public participation is 224,907. My Lord, out of over 50 million Kenyans who have attained the age of 18, because of the shortness of the notice, only 224,907 were able to participate. But Lord, that is dismal. That is not public participation. And Article 118 and Lord, Article 118 requires Parliament to facilitate public participation. The Supreme Court has said the notice must be reasonable, must be adequate, the public participation must be meaningful, not a show. My Lord, 224 or 225, even if you are to leave aside the 50 million Kenyans who are above the age of 18, even the registered voters are 14 million. This is demonstration of the fallacy, of the mockery of the public participation. And my Lord, on the same RG 11, RG 11 at page 7 790. Page 790 is volume 2 again. Page 790. My Lord, at the top of page 790, my Lord, you see the constituency there, 95, Keyo South. My Lord, if you go to the column showing support, it shows 162.79% support. My Lord, what could demonstrate 162.79 support? In other words, apparent there of all the registered voters shot through the support to 100, even if all the people who turned up for the public participation said yes. How does the figure go to 162.79, actually virtually 163%? My Lord, is this data on which this court should allow that resolution to proceed for the impeachment of the deputy governor? And my Lord, yes, my Lord. Yes.
That constituency, I don't know if this figures in fact, the total 43.
There?
Yes.
There is 70.
Yes.
And then I do not support.
3.
And then that would be how many?
I'm just pointing out,
Yes.
because they tell us the total number who turned up were 43. Then how come 70% supported, if the total number?
That column is the same as the column with what? The grand total. You go to grand total.
Yes, the grand total
Page
appears in
812.
column 2, yes. Where the
It's the same column.
202nd column. List the constituencies. But
So at page 812,
8, yes.
at the top, that is it's called columns and not rows. The column shows total responses, right?
Yes.
And this is per constituency,
Yes.
and the national tally is at 224. Correct?
That is correct.
That's the same.
Yes.
Then in the case of KO, I would assume the total of those who turned out are 43.
That's what we were told.
And then those who support are 70.
Yes. Contradiction.
And then 3 do not support. So that takes us to 100, over 100.
Yes.
Okay, proceed.
Followed. The other submission also in here. The petitioner, who is the subject matter of impeachment, should have been accorded an opportunity to answer to the allegations, so that the allegations and the petitioner's response are then taken to Kenyans in the public participation. For them to be able to make an informed decision. Only the allegations were taken, not the response of the petitioner. Is this public participation as envisaged in Article 118 of the Constitution? The answer has to be a resounding no. Lord, there was no adequate time when this data was returned to Parliament. We don't have how it was evaluated, because the purpose of public participation is that the views of Kenyans are taken into account when the National Assembly is then debating and passing a resolution. And then, can I have it? No, the data. The data. Yeah. My Lord, the public is denied the evaluation by the National Assembly of the data that was collected. If you go to page 813 of volume 2, 813, 813 at the bottom. The independent, credible pollsters shows, number one there, that only 2,236, 7% voted in favor of impeachment of the petitioner applicant. Sorry, my Lord. The opinion polls, they conduct online opinion polls, and when the figures in Parliament are saying the opposite, this independent pollster shows only 7% was supporting the impeachment of the deputy president. Double that number, 14%, 4,433, supported the impeachment of the president, although it wasn't part of the questionnaire. And 75% of the Kenyan people, 24,122, said the president and his deputy should be impeached together. So the overwhelming majority in this limited public participation voted in favor of both being impeached, but 93% were against the impeachment of the deputy president. My Lord, My Lord, in our list of Board of Authorities, at page 36, my Lord, you see the case, the Supreme Court case of Peter Gatira Omunya, and the passage I want to draw the court's attention to appears at page 52, paragraph 97.
Paragraph 7 of the decision.
Yes, 97 of the decision.
Say 97.
97. If you permit me very quickly. Bearing in mind the nature of the competing claims against the background of the public cause, we have focused our perception on the public interest and the concept of good governance that runs in tandem with the conscious deployment of scarce resources drawn from the public. Proper husbandry of our public monetary and other resources, we take judicial notice in a major challenge to all active institutions and processes of governance and the court by the established attributes. Line drawing must ever have interest in contributing to the resources. And at paragraph 86, perhaps I should have started with it, the Supreme Court says conservatory orders bear a more decided public law connotation. For these are orders to facilitate ordered functioning within public agencies, as well as to uphold the adjudicatory authority of the court in the public interest. Conservatory orders, therefore, are not, unlike interlocutory injunctions, linked to such private party issues as the prospect of irreparable harm occurring during the pendency of a case or the high probability of that success in the applicant case. Conservatory orders, consequently, should be granted on the inherent merit of a case, bearing in mind the public interest, the constitutional values, and the proportionate magnitude and priority levels attributable to the relevant cases. My Lord, on the very day that My Lord, on the very day that the National Assembly concluded debate on these unsatisfactory results, at 9 p.m. at night, they passed a resolution. That resolution was transmitted at night to the Senate. And the Senate has issued its timelines, and we have annexed the timetable to the supplementary affidavit. You will see the Senate timelines at page 13, saying they will deal with the impeachment on Wednesday, the day after tomorrow, Wednesday and Thursday. So, my Lord, we plead that you grant us a stay of that resolution, a stay of the impeachment in the Senate, to accord time to this court to hear these very weighty constitutional issues, preserve the substrata of the petitioner's case. Because, my Lord, when you look at the speed with which this matter is being moved by whoever is controlling the levers, by Thursday, when the Senate concludes, if they conclude to remove the deputy president. My Lord, within the hour of their doing that, it is our submission that one can expect a deputy president will have been appointed. The entire substratum, the subject matter, will become moot, will become academic. The petition and this notice of motion will be rendered, will have been rendered nugatory. This court has to stamp its authority in favor of constitutionalism, in favor of the rule of law. My Lord, we are at crossroads. We either go back to the imperial presidency, where the constitution is replaced by the wishes of whoever is the president, or we go back onto the rails where we are a nation governed by the constitution and the rule of law. So, my Lord, it is my plea that your Lordship stands up for the nation, that your Lordship refuses to be intimidated in any way. My Lord, we've seen some of your colleagues whose security have been withdrawn, some allowances of judges being taxed, my Lord, the budget of the judiciary being reduced. My Lord, stand up against this. Don't allow any of this to interfere with your functions as a judge of this High Court. My Lord, because I don't want to take time, I draw your court's attention, your Lordship's attention, to the decision in the case of Joseph Enoch Aura versus others. You find it at page 219 of our Bible of Authorities. Joseph Enoch Aura, page 219 in our Bible of Authorities. And at page 223, paragraph 5 of the decision, you will see your brother judges, Mavea, and there were 3 judge bench in that case, giving the minimum conditions for effective.
Did you say paragraph 5?
Paragraph 5 at the top. Paragraph 5 at the top, page 223.
What is the paragraph of the decision?
It is paragraph 5 of the decision. It is to be found at page 223. My Lord, the conditions are there. Minimum. Proper sensitization on the nature of the legislation to adequate notice. 3, facilitation of the public. The views of the public should be considered, and where they were to be rejected or declined, the reason for such rejection or dismissal. Public participation should be inclusive, should reflect a fair representation and diversity of the populace. There must be integrity and transparency of the process. None of this was observed in the public participation, quote and unquote, that was conducted in this case. My Lord, the only way to promote and preserve constitutionalism in the rule of law is to grant us a limited stay. Your brother, the Honorable Justice Mugambi, actually certified there are very weighty issues in those other cases. And they are. The new dimension has been brought in this case by the passage of the resolution. But the issues remain weighty. Preserve the position, at least to give time for that three-judge bench, perhaps to include this case, alternatively to give this court time to hear full arguments on the violations, including the constitutional validity of Standing Order number 64. And as I sit down, my Lord, let me mention that this requirement for public participation acquires added significance in a presidential system of government. That requires we no longer have any confidence in you as a president or deputy president, but gross violations of the law, not just violations of the Constitution, but gross violations of the law or other law. My Lord, the word gross is to be interpreted as justem generis. Violations of those other laws have to be gross. Why? Because it's a person that millions of Kenyans elected. In the particular case of the petitioner here, over 7 million Kenyans voted for him. So it's not an issue of we don't have confidence in you. It's not an issue of we don't like you. It's you must satisfy the requirement of gross violation of the law. I'm merely saying preserve this situation until we are able to argue these matters. I hand over to my colleague, Tom Acharya. I thank you, my Lord.
My Lord, just to note that my colleagues have taken 41 minutes.
I'll be very brief, my Lord. I rise to make only 3 points. In response, my job is to carry Mr. Mwita's books. I'll be very quick now. In summary, Lord, stripped to its bare essentials, what my learned colleagues for the respondents will be telling you shortly is that this honorable court has no jurisdiction on 3 primary limbs. They will tell you that the doctrine of separation of powers precludes you. They will tell you, secondly, that the dispute before you is not ripe. They will tell you, thirdly, that the matter is sub judice and should therefore not be heard for you. They will cite for you, my Lord, an authority listed in the, I believe, grounds of opposition of my good and learned friend, Mr. Kuyoni Josephat, for the Attorney General. This is the case of Mate and another one versus Wambora and another. My Lord, that decision is wholly distinguishable from the case before you, because what had happened when my Lord interrogates the circumstances, a court order was obtained in the middle of deliberation and debate by the County Assembly of Embu. In contrast, my Lord, the matter before you has a ripe resolution which we have attached, my Lord, to the petition. These are the words of the Speaker of the Senate, my Lord, in that document. This is the resolution. I'm reading directly from the resolution. Whereas on the 8th of October 2024, the National Assembly, having considered the special motion resolved by the support of 282 members, being at least 2/3 of the members of the National Assembly, that pursuant to the provisions of Article 142 as read with Article 151B of the Constitution, the Deputy President of the Republic of Kenya be removed from office by impeachment on the grounds specified in the special motion. In the words of the Speaker, and I also have the words of his advocate present before you here, my Lord, the impeachment is complete. Allow me to read the words of my good friend Mr. Milimo. This is the ruling, my Lord. We've attached it in the further affidavit before you when they appeared before Justice Mugambi. This is what he cited. Mr. Milimo, for the first respondent, argued that the matter of impeachment has already been concluded in the National Assembly, and the Speaker is no longer presiding over the proceedings of impeachment. My Lord, you have a decision before you, ripe, complete, concluded, that you can review. The second issue, my Lord, that will be raised before you is the question of sub judice, my Lord. You will be told that there is another matter pending. Three things to say on that, my Lord. Under the Mutunga rules, the rules under the Constitution on the fundamental rights of the citizens of Kenya, a citizen of Kenya can initially approach the court even on a foolscap, on a tissue paper, and subsequently augment that tissue paper with a complete petition based on circumstances as they arise. Secondly, my Lord, there has been no time, and there can be no time, and the court has already noted, to file an application to amend any initial petition. And so what the parties did, when circumstances changed and an entirely new case arose, my Lord, the petition before you was filed. The remedy, if any, my Lord, is to stay the first petition, my Lord, in view of the fresh petition that raises fresh issues that could not have been covered with that first petition and given the constraints of time. My Lord, the third thing, and this has to do slightly with the question of ripeness, are that the principles on the principle of ripeness have exceptions. My Lord, we have cited before you a case of the United States Supreme Court. This is the case of Abbott Laboratories versus Gardner. My Lord, I would call your attention with tremendous respect to the passages at page 12 and page 13 of our bundle of authorities. Pages 12, the paginating, my Lord, is at the bottom right-hand corner. Page 12 and 13. It's an important case, my Lord, because it was a case determined by the U.S. Supreme Court in 1967 and is in fact the origin of that principle in our own jurisdiction. And what the court there said, my Lord, is that where a litigant has a pressing matter that will be rendered nugatory or that must be dealt with immediately, ripeness does not apply. Examples, my Lord, and we've cited before you, when you read the submissions, there's a case called Stanislas Nyagaka Ondemu versus Kaleisoi Farmers, where you're to be jailed for contempt or to be jailed under other circumstances. It serves no purpose in justice to argue that we must wait for your jail term to become ripe before the court can help you. My learned senior, my Lord, has identified several other cases, several other circumstances, particularly in this one. But allow me, my Lord, to read the words of your brother Justice Mugambi in the ruling delivered on the 11th of October. This ruling, my Lord, is attached to the further affidavit at paragraph 38. Towards the end, I'll read very quickly, my Lord. And considering the immense public interest this matter has generated, and being the first of its kind in Kenya where the Deputy President of the Republic is being removed by process of impeachment, It is my considered opinion that this matter deserves the input of the bench so as to pronounce itself on a process that is constitutionally compliant to serve as benchmarks for future undertakings of this nature. It is necessary for the citizenry of this country to know whether the current state of law allows them adequate opportunity to participate meaningfully in the process of the removal of the Deputy President. We have also attached a court order from Kerugoya, my Lord, that required the Senate to conduct public participation. My Lord, that is in my Lord? The one I've read is paragraph 38. It's a very long one. I read the last quarter of it. Yes. The ruling is paragraph 38, 39, and 40, my Lord. The ruling from Kerugoya, my Lord, I refer to, which is attached to the affidavit filed this morning, had an order number 5, that the first to fifth respondents shall organize, the fifth respondent, I believe, is the Senate, in that matter before Kerugoya, shall organize similar public hearings closer to the citizens, at least at constituency level on each constituency in Kenya, to enable the constituents of members of parliament responsible for the impeachment process nationally to engage with and participate on hearings. The Senate is a party to that case and was one of those required to undertake public participation. When my Lord looks at the calendar produced by the Senate from pages 12 to page 14 of that supplementary affidavit, there is no room provided for public participation in violation of that court order. Let me end with this, my Lord. My colleagues from the respondents are about to astonish you and astonish Kenya with the following submission. They argue that this court has no jurisdiction even after the Senate has concluded its affairs, because in their view, Article 165, Subarticle 3C should be read in pari materia with Article 145. They say that Article 144, which deals with removing a president and deputy for incapacity, the court has no jurisdiction. And that is true, because Article 144 says so expressly. But they say you must extend that thinking.
My Lord, can he reply after we have said?
It's before me. I'm just explaining. Well, I know they don't want me to take away their mouth, but it's a point of law. Yes. Okay. Yes. Yes. Okay.
So you are moving your application and responding to them.
Okay, I'll then await to respond to that question. I just wanted to say they make two. Yes. Oh, I see. Very good. So, my Lord, under Article 165, Subarticle 3C, the court has no jurisdiction where the removal of the president is incapacity. The respondents argue in their PO and in their grounds that must be read in pari materia for Article 145. My Lord, the law is this. Unless the jurisdiction of the court is expressly denied by a statute or by the Constitution, it cannot be denied, my Lord. The authorities are on this point. But that is in contradistinction to the other argument they make. They say this court cannot now interfere until Senate has finished. But when Senate finishes, they will then come and argue the court doesn't even have jurisdiction. This is the argument, the astonishing argument being made before you. And this is an argument that 450 people in Parliament can take away the sovereign power of the people under Article 1, and they cannot answer to a court of law. This is the argument before you, which is why I say it's astonishing. They can remove the president, they can remove a deputy president, but that no one can hold them to account. That, in a sentence, is the argument the respondents are coming to make before you. And my Lord, I would urge you with tremendous respect, reject that argument on the basis of the numerous authorities this court has made before, that it is the guardian of the Constitution. My Lord, thank you very much for your time and for the privilege of your attention.
My Lord, we have agreed that for the second respondent to go first with your Lordship's indulgence. And perhaps maybe your Lordship can give us a direction, bearing in mind the amount of time taken by the petitioner, whether there is any adjustment or correction in the time allocation. Beg your pardon? You gave us 25 minutes. Most
likely, bearing in mind we were responding to how many respondents?
I am happy with the 30 minutes, and we shall constrain ourselves to the 30 minutes. My Lord, the application before you is opposed. And my Lord, I wish to begin our opposition to that application by making the argument that the petitioner or the applicant before you this afternoon or this morning is guilty in the most crude fashion of forum shopping. My Lord, I wish to place on record what my humble understanding of forum shopping is, and it is as follows. Where a party knowingly files various matters before courts of law, seeking the same relief about the same issue and hoping against hope for a different outcome. With that in mind, I wish to state the following, my Lord. My Lord, the relief or the prayer, the only prayer that the petitioner has argued before you this afternoon is prayer number 5 in the notice of motion dated the 11th of October this year. And with your Lordship's permission, I will read that prayer to you. It says that upon the hearing, upon inter partes hearing, and pending the hearing and determination of the substantive petition hearing, a conservatory order be issued restraining the Senate as a whole from admitting, processing, dealing, or in any other manner whatsoever considering the motion for the proposed removal of the Deputy President from office by impeachment founded on the notice of motion of the National Assembly dated the 6th of November 2024. And 6th of November is not written as it is ordinarily written, it is abbreviated as 26/9/2024. My Lord, that prayer is identical to prayer number 6 in the notice of motion dated the 2nd of October 2020. It is identical to prayer number 6 in the notice of motion dated the 2nd of October 2024 in petition number 522 of 2024, whose parties are identical to this one. Number 522. My Lord, that prayer, because it is important, I seek your indulgence to read it, reads as follows. That upon inter partes hearing and pending the hearing and determination of the substantive petition hearing, a conservatory order be issued restraining the Senate as a whole from admitting, processing, debating, or in any other manner, or in any manner whatsoever considering the motion for the proposed removal of the Deputy President from office by impeachment founded on the notice of motion to the National Assembly dated, and again the date is written 26/09/2024. It is the same prayer. My Lord, the issue of Standing Order number 64 and the constitutionality of public participation is an issue in petition 522. Standing Order number 64 of the National Assembly, and whether or not public participation was carried out as required by Article 118 are issues for determination in petition 522, and I will demonstrate that in a moment, my Lord. by reference to the decision of your brother, Mr. Justice Mugambi, in petition 522 delivered on the 11th. My Lord, curiously, my Lord, the notice of motion before you at prayer 7, at prayer 6, contains the following prayer. It states that upon inter partes hearing of this application, I'm reading prayer 6 in the notice of motion dated the 11th of October. And my Lord, that prayer says that upon inter partes hearing of this application or such earlier time as the court may determine, this honorable court be pleased to certify that this matter raises questions of great general public importance, fit for empanelment of a bench of an uneven number of judges for hearing and determination. That is the prayer for empanelment. My Lord, that prayer is prayer number 7 in the notice of motion dated the 2nd of October in petition 522. My Lord, that prayer was argued and determined substantively by your brother, Mr. Justice Mugambi. And that prayer number 6 has not been urged before you today. My Lord, it is important that as you consider the allegation that we have made that the petitioner is guilty of forum shopping, that you, when you retire to consider your decision in this matter, consider the following paragraphs in your brother Mr. Justice Mugambi's ruling delivered in petition 522 on the 11th of this month. My good and learned friend Mr. Masharia has referred to that ruling, and I am referring to the same ruling as he did. My Lord, at paragraph 6, and I will read it quickly, your brother Justice Mugambi records the proceedings as follows: that Mr. Paul Mwite SC for the petitioner in paragraph 6. Mr. Paul Mwite SC for the petitioner in E522 of 2024 submitted that the petition indisputably raises weighty constitutional questions, which he highlighted. This included: 1. The constitutional validity of the standing orders of the National Assembly used to process the impeachment, particularly Standing Order number 64. That is the argument that senior counsel made before you. Your brother goes on to say, which he faulted for providing a short duration of 12 days to complete the entire impeachment process, whose impact it was to impede the adequate and meaningful public participation, a critical constitutional requirement. Again, the petitioner is on record in this matter that is the important issue in this matter. But instead of arguing it as they did in 522 to get certification, now they want conservatory orders. He goes on at paragraph 7. Mr. Mwite further contended that the impeachment process in the National Assembly is a quasi-judicial process and must comply with the provisions of Article 50. My Lord, that again is the argument that was made before you. This is the same issue, the same petition as 522. I wish to jump quickly to paragraph 38, which my good and learned friend Mr. Masharia referred to the end. But the beginning is also important. In paragraph 38, your brother, Mr. Justice Mugambi, states as follows: I listened attentively as the issues in contention in these petitions as they are being canvassed by the party's advocates. On the issue of constitutionality of the standing orders, the respondent strongly opposed the contention that, that it amounts to a substantial question of law because such issues have been litigated before He then went on to point out that I was keen, however, to pick out the unique challenges that the petitioners have pinpointed in assailing the standing orders that the National Assembly relied on to carry out the impeachment process. Again, it is standing order number 64. It is the same issue that is before you here. In paragraph 39, there was also the question of whether the allegations whether the allegations subject to an impeachment should be circulated to the public with or without the responses from the person being impeached. That was the question that Learned Senior Counsel asked. He impeaches the public participation process for not giving the public an opportunity to consider the Deputy President's responses. It is the same argument that was made before Mr. Justice Mugambi. Paragraph 41, my Lord. Finally, that notwithstanding the voting in terms of the numbers in both the National Assembly and the Senate on the impeachment motion, if the jurisdiction under Article 163 extends to interrogating the materials relied on under Article 145, so as to determine if the threshold to support the allegations was established, either in the National Assembly or the Senate or both. By the time this petition was being filed, it anticipated a challenge to the process in the National Assembly and the Senate. And your brother, Mr. Justice Mugambi, then goes on. I find that given the extensive nature of these proceedings, starting from the National Assembly all the way to the Senate, and due to the massive public interest in the matter, and he then goes on in paragraph 42 to certify this matter as one of great public, he certifies it under Article 163(4) of the Constitution, refers the matter to the Chief Justice. My Lord, I believe I need to say no more to demonstrate that this is the same petition as petition 522. And my Lord, forum shopping arises not from the identification of a judicial officer, but merely the act of filing an identical petition. We all acknowledge that these days when you file, the CTS will allocate it to any judicial officer in that division. My submission is that forum shopping takes place when you file an identical petition seeking the identical relief. My Lord, it has been stated in response to the allegation of forum shopping that a new issue has arisen. And that new issue, my Lord, has been identified as the fact that the National Assembly passed its resolution or considered and passed its motion, and that is what has then given a rise to this cause of action. My Lord, it is not disputed that the National Assembly passed its motion on the 8th of October this year. And again, my Lord, you will clearly see from the ruling of your brother, Mr. Justice Mugambi, that the parties before you today were before him on the 9th. On the 9th of October this year. And my Lord, the fact that Mr. Justice Mugambi's ruling of the 11th of October takes on board the fact that the challenge by the petitioner is both to the proceedings in the Senate and National Assembly, I submit that it was then the petitioner's duty in petition 522, when we were before your brother Mr. Justice Mugambi on the 9th, to point out in petition 522 that there were new facts that necessitated his consideration of prayer number 6 in the notice of motion dated the 2nd of October that was before him. That prayer is the same prayer as prayer number 5 that has been urged before you today. That was the right thing to do. My Lord, that having not taken place, and the petitioner having elected to file this petition and the notice of motion that is before you this afternoon, that deed by the petitioner amounts to forum shopping. And I urge your Lordship, therefore, not to proceed and hear and make a determination on the notice of motion that is before you in petition 550 of 2024. My Lord, a possible way out or a remedy has been suggested by my good and learned friend Mr. Macharia, that the remedy is to stay these proceedings. Or the remedy is to stay 522. My Lord, that request or that motion is not before you. And I submit that, my Lord, the correct thing to do, petition 522 being the first in time, and so as therefore, my Lord, not to be an accessory in forum shopping, what your Lordship should do is direct that this petition be consolidated with petition 522 of 2024, and any relief sought in notice of motion dated the 11th of November, 11th of October, 2024, be canvassed in the consolidated petition 522 of 2024. Any prayers, any relief that is sought, notice of motion dated the 11th of October, 2024, be canvassed within the context of that consolidated petition. To go on and entertain and make a determination as you have been invited to by the petitioners, would my Lord, would then be facilitative of forum shopping. My Lord, my learned colleagues who will submit after me will submit extensively that the process which the Senate has now embarked on is guided by certain constitutional timelines. And in deference to those constitutional timelines, my Lord, the remedy that the judiciary has come up with is to acknowledge that the High Court's ability to examine, if it has that ability, is postponed until the constitutional process, governed by strict constitutional timelines, set out in Article 145, Sub-Article 3, 4, 5, 6, and 7 of the Constitution, is completed by the Senate. My Lord, I am of the view that you should not consider any of the substantive arguments that have been made in support of the notice of motion in respect of public participation or otherwise. But my lord, if you are in the unlikely event minded to consider those arguments, I wish to submit that the total population of Kenya is not a factor to be considered when determining whether public participation was effective or not. Article 118 of the Constitution places an obligation on Parliament to facilitate public participation. But the public have no compulsion to participate. There is no corresponding duty in the Constitution that when public participation takes place, then all citizens or a certain category of citizens of Kenyans must participate. And my lord, if that argument were to be given any credence, then it would be possible to challenge the election of an elected official by reference to the turnout of voters. You are elected in constituency X where there are 20,000 registered voters. Only 2,000 came out and voted in the election in which you were returned. That is the way the Constitution works. There is no compulsion that everybody takes place. There is no threshold set out in the Constitution for a return on public participation. Again, my lord, the reference to an opinion poll and to pollsters is again irrelevant in assessing the adequacy or the efficacy of public participation. I submit, my lord, that in promulgating the Constitution in 2010, the people of Kenya were very deliberate as to the structures and institutions they set up. There are thresholds contained in Article 145, and those thresholds refer to numbers of members of Parliament, both of the National Assembly and of the Senate. And if there are any numbers to be referred to, it is those set out in Article 145. My lord, there is an allegation that there was a resolution passed at night and there was a concern at the speed at which the process is taking place. Again, in that submission, there is no statement that the second respondent proceeded or sat irregularly, or that the transition of the resolution from the National Assembly to the Speaker was irregular. My lord, all of them took place within the prescribed constitutional parameters. This is not impeachable unless it can be established that they took place outside the time prescribed by the Constitution. My lord, in respect of the order from your brother, Mr. Justice Mwongo, in Kerugoya, and I'm glad to note that my learned colleague, Mr. Ndego Njiru, is now present. When we were before Mr. Justice Mwongo, an attempt to make these submissions that have been made on the part of the petitioner, that there was non-compliance with that order, were made. Mr. Justice Mwongo, and you will see from the pleading, direct that nevertheless, that Kerugoya matter be consolidated with matter before the three-judge bench. And my substantive submission is as follows. There is a petition in Kerugoya where Mr. Justice Mwongo gave certain parameters in which public participation must take place. I believe it is petition number 14.
It's in his supplementary affidavit.
It is in the supplementary affidavit filed, RG 19. My Lord, my submission is that this cannot then be the forum in which that order is enforced.
Is there a bench already established?
There is a direction that a bench will be established. I am not sure whether Her Ladyship, the Chief Justice, has established a bench. This matter is not consolidated with the matter where the Kerugoya matter has been consolidated, and it cannot then be a proper exercise of this court's jurisdiction to turn petition number 550 of 2024 into the enforcement proceedings, orders made in petition number 14 of 2024 in Kerugoya. I yield the rest of our available time to Mr. Gumbo and Mr. Wanyama to conclude our missions. I'm most obliged. My Lord, perhaps if you could be kind enough to add us some time. I was making submissions on an important issue, and I believe we all agree that it is important. My Lord, we are entirely in your hands. What we seek for is a little more time so that we can put the other issues. No, I would not ask your Lordship for the entire day. On top of what we have, my Lord, would you consider 10 minutes? Then maybe 10 minutes so that we conclude? We use the 4 that we have plus 6 more?
Because each one of you ask for time extension. So how much time is it?
I leave it entirely to you, my Lord.
Conclude. I'll give you another 3 minutes. That makes 7.
My Lord, have you factored in the time that we stopped?
Decision has been referred to in rather the matter that is filed before Kerugoya, your brother Justice Mongo. I just want to add one small thing to that matter. My Lord, a lot of submission has been made in relation to rather the matter that is filed before Kerugoya, your brother Justice Mongo. I just want to add one small thing to that matter. My Lord, a lot of submission has been made in relation to whether there's been compliance with that direction or the directions of your brother in Justice Mongo in Kerugoya in petition number 14 of 20. That a question as to the compliance or otherwise with the directions of your brother Justice Mongo can only be made, my Lord, in that very file. That file is before you. My Lord, you'd be handicapped, plans or otherwise, with the directions of your brother. Very quickly then, my Lord, to plans or otherwise with the directions of your brother. Very quickly then, my Lord, to a submission in relation to Article 145, my Lord. This entire process is hinged on Article 145 of the Constitution. Article 145(1) relates to the process in the National Assembly. My Lord, submission has been made before you from both sides of the bar that process has been concluded. In fact, that there's been a resolution that has been sent to the Senate pursuant to the provisions of Article 145, 1 and 2 of the Constitution. My Lord, why that is important is that it signifies that Article 145.3 has kicked in, which means that the Senate is now properly seized of the matter. In fact, learned senior counsel, Mr. Muite, did indicate that that is accurate, that this matter is meant for determination and deliberation, that is accurate, that this matter is meant for determination and deliberation on Wednesday and Thursday of this week. My Lord, if that be the case, where then is the efficacy of issuance of any conservatory order? We ask ourselves, my Lord, that given the jurisprudence that has emanated from this court, the Court of Appeal, and the Supreme Court, the position, my Lord, has been that deference and judicial restraint should then be exercised so that the process that starts from the National Assembly into the Senate is completed. It is only then that the High Court would come in, if at all, to inquire as to whether anything done under the provisions of the Constitution is indeed done in compliance with the Constitution. My Lord, I in particular make reference to decisions that have been placed before you. There is a decision by the Supreme Court in Supreme Court Petition number 11 of 2022. Mike Mbuvi Sonko. My Lord, it appears as, I think, number 7 in our list and bundle of authorities.
What are those bundles? You keep on talking about bundles. They're in the system.
Yes, my Lord.
And I'm here.
My Lord, I think that's why we were trying to draw the difficulty that we found ourselves in, because we received them this morning. We received submissions this morning. We received bundles this morning. It is only today that we could respond. My Lord, can I suggest that we can print and avail them before you?
Stating right to them. Because I'm supposed to look like what you're telling me. And if I are doing that, let I do so.
My Lord, can we give an undertaking to print those documents, avail them before you shortly after proceedings? Thank you, my Lord. My Lord, in the Mike Mbuvi Sonko matter, we particularly refer you or invite your attention to the to paragraph 136. My Lord, to paraphrase, the Supreme Court expressed itself to a worrying trend where there is litigation that is conducted before another constitutional process is carried out. And in their wisdom, they gave guidance that in such instances, my Lord, the courts would exercise, again, the decision by the Supreme Court in a case of Justice Kariuki Mate and others. That's petition number 32. Again, the decision by the Supreme Court in a case of Justice Kariuki Mate and others. That's petition number 32 of 2014. It appears as number 8 in our list of authorities. I invite your attention to paragraph 61, 62, and 63. Petition number 32 of 2014.
Paragraph
61, 62, and 63. It is possible to formulate certain principles as follows. A, each arm of government has an obligation to recognize independence of the other. B, each arm of government is due to refrain from another organ or how to exercise its mandate. A, each arm of government has an obligation to recognize independence of the other. B, each arm of government is due to refrain from another organ or how to exercise its mandate. C, that the courts of law are the proper judge compliance with constitutional edict, all public agencies. But this is attended with the duty of objectivity and specificity in the excess of judgment is due to refrain from another organ or how to exercise its mandate. C, that the courts of law are the proper judge compliance with constitutional edict, all public agencies. But this is attended with the duty of objectivity and specificity in the excess of judgment. They end by saying, my lord, that when such matters are then presented before the court, then the court is restrained to only intervene after the entirety of that process has been completed. My lord, the last thing that I would want to speak to is a question of whether that will be occasioned in the event that the orders sought are not granted. My lord, our Constitution, specifically Article 145 sabbatical, has an inbuilt safety valve, inbuilt mechanism that, number one, provides for an opportunity for, in this case, the petitioner. Article 145 gives an opportunity valve gives an opportunity for, number one, the petitioner to be heard before a determination is made. But what's more, that after this process would have been concluded to whether the entire process was in compliance with the Constitution. So at no point, and the courts are always able to fashion appropriate remedies at whatever point in time when such issues are raised. My lord, lastly, it should not be lost on us that the Kenyans, in framing this specific Article 145 of the Constitution, just like most of the other provisions, were very mindful of the need to determine and conclude these matters with urgency. That is why timelines are therefore defined for the completion of these processes. In the case of this impeachment, my lord, the Constitution at Article 145, Article 3, sets a timeline of 7 days. Granting order may then mean extending the scope of that constitutional act. 145, Article 3. It then means, my lord, that if interventions were to be gotten this point in time, then as of necessity, it will put the other actors, the other state organs who are indebted to also independently carry out their obligations in a difficulty in terms of those orders. My lord, that is not a situation that a petition is supposed to precipitate if the Constitution was to be read holistically. I stop at that unless there's any other question. Yes, madam.
And the same Constitution says at the end of the exercise,
yes,
another person should be there within a period.
So first, it gives a period of 14 days within which then the president can nominate a person to be considered by the National Assembly for the position of deputy president.
That means within 14 days there should be someone.
Yes, but then if that is not the end, because that person again is subject to approval by assembly for within another 60 days.
No, we have not gone there. We are still at the stage where there should be someone.
Yes.
What happens then? When we be asked, what happens then? When we be asked the same question that now Constitution provides the same timeline, you cannot intervene.
Not quite. You know, the independent processes that as I look at them alone, once that entire process has been completed and a determination made, the provisions that then govern the question of replacement are completely different. At that point in time, in my humble view, the court can consider a question as to whether what has been done can then is in compliance with the Constitution. Thank you, my Lord.
Yeah, thank you, my Lord. I will not take a lot of time, just address the issue of conservatory orders. Yes, my Lord. Thank you, my Lord.
I've added it from 25 to 30.
That's all, my Lord. I'll take that time. My Lord, I will begin first of all by submitting on the practical implications of the orders of the proceedings before your brother, Justice Mugambi, in petition 522 of 2024, vis-a-vis these proceedings. My Lord, and I want to make the firm submission that, my Lord, the petitioner in this matter, who is the petitioner in 522 of 2024, is precluded by the doctrine of estoppel of record. From raising issues, and my learned colleague Mr. Paul Nyamundi has raised these issues, raised this point, issues that he has raised in petition 522 in this instant petition. My Lord, let me just be very clear that in 522 of 2024, my learned colleague Mr. Ongoya, as led by Senior Counsel Paul Mwite and assisted by Faith Waigu and Mr. Mashare, who are in these proceedings, firmly told the court and submitted in this very bench that they were not pursuing the prayer for conservatory orders. At that very moment when they were making those submissions, the proceedings in the National Assembly with respect to impeachment, phase 1, had been concluded. So, my Lord, they only pursued one question. That is the question of certification. My Lord, actually, if you look at the proceedings, they raised an objection. My Lord, they raised an objection, my Lord, to our submissions opposing conservatory orders, stating that it was not one of the matters which they wanted canvassed. But, my Lord, the implication of these submissions,
do I understand you to say that they didn't want you to respond to the application for conservatory orders?
yes, my Lord, in petition 522 of 2024, because according to them, they didn't want to argue that petition, that aspect of the prayers. All they wanted was for certification. So, my Lord, if you now look at the ruling of Justice Mugambi, he only addressed the issue of certification. So that, my Lord, in terms of the implication, our submission is that if there is any value to be derived from this application, the value is for them to ask that this application be consolidated with petition 522 of 2024. My Lord, that will be consistent with the Mutunga rules, especially Rule 2. And, my Lord, public policy in the judicial decision making. My Lord, public policy in judicial decision making. my lord, which requires consistency, that litigants need to lay a platform for consistency in judicial decision making, so that there is no conflict from decisions which are rendered by our honorable judges. So, my lord, that public policy will be given effect by the order for consolidation, which, my lord, you have jurisdiction, inherent jurisdiction to make, even when they have not asked for that order today. You have inherent jurisdiction to make. My lord, I'll briefly mention the test on the ground of conservatory orders. My lord, they have submitted, the petitioner submitted that he wants conservatory orders to stop proceedings in the Senate. My lord, my submission is that if you examine the nature of proceedings for impeachment, my lord, Article 145, these proceedings have not completed. My lord, proceedings in the National Assembly and proceedings in the Senate are one continuum. My lord, both the National Assembly and the Senate. So, my lord, there is no decision yet by this arm of government with respect to impeachment to of necessity require this court to issue conservatory orders at this stage of these proceedings. So, my lord, if you look at the test for the grant of conservatory orders, which my colleague, senior counsel Paul Mwite cited, in the case of Peter Gaterau Munya, my lord, my colleague didn't cite the last part of the test. My lord, which requires you to consider, my lord, and make a delicate decision, apply the doctrine of restraint and make a delicate juridical decision to allow these proceedings to go on. Why, my lord? Because of a foremost constitutional value known as the constitutional doctrine known as the doctrine of separation of powers. My lord, these proceedings which are before the Senate are legitimate constitutional proceedings. My lord, public participation has been conducted. They can question the adequacy of that public participation, but my lord, public participation has been conducted to a sufficient degree of acceptability. My lord, that is why in the response, my lord, you can see numbers being quoted by the petitioner. So, my lord, if I submit that if there was no public participation in these proceedings, in the impeachment proceedings, my lord, then that will have made a lot of sense to injunct the proceedings at any time when the petitioner comes to court, because, my lord, public participation is a core constitutional value. So, my lord, because public participation has been conducted, the delicate exercise of judicial function, the petitioner comes to court, because, my lord, public participation is a core constitutional value. So, my lord, because public participation has been conducted, the delicate exercise of judicial function, my lord, then requires that you hold on a little bit. You don't issue precipitate conservatory orders to stop this legitimate constitutional process of impeachment. My lord, the implication on the opposite side is that, my lord, these proceedings are not about criminality, impeachment proceedings. My lord, they are about political responsibility. And my lord, in the design of the 2010 Constitution, my lord, they exist in the constitutional and legal order for good reasons, my lord. My lord, they exist so that the legislative arm of government is able to hold certain state officers, my lord, into account. So, my lord, they are not illusory or unknown proceedings to law. They are proceedings which are recognized by Article 150, Article 145, and Article 146 of the Constitution. My lord, secondly, these proceedings are time-bound. My lord, in the case of Justice Kariuki Mate, and my lord, the case of Justice Kariuki Mate, my lord, is a typical case, my lord, for you to apply in this matter, because, my lord, the facts appear to be tailored for this kind of situation. My lord, petition 32 of 2014, Justice Kariuki Mate versus Martin Nyaga Ombora. A similar matter, my lord, where you, my lord, petition number 32 of 2014. My lord, and I would like to briefly, my lord, reflect on what the Supreme Court has said in paragraph 83 of this decision. Paragraph 83 of the decision. 83, my lord. So, my lord, the Supreme Court is asking itself a question. That, my lord, should ex parte orders be issued? And in this case, my lord, we are reformulating by interpreting, because the implication is the same. Be issued, my lord, with respect to proceedings which are active before the legislative arm of government. And, my lord, you can see here the Supreme Court is restating the doctrine of separation of powers as one of the principles which shall guide you in that paragraph 83. Because, my lord, the implication of the conservatory orders is that then the proceedings, these time-bound proceedings, my lord, these time-bound proceedings before the legislative arm of government will then be stopped. And, my lord, I submit that it is not unique for the Constitution to require this kind of proceedings to be time-bound. And, my lord, in paragraph 84, to require that you exercise what the Supreme Court judges are called inner restraint. Inner restraint. Because, and my lord, the Supreme Court is saying exercise this inner restraint in the context of express mandate allocated under the Constitution to Parliament. And, my lord, the idea is to circumvent and avoid conflict and crisis. Conflict and crisis in the discharge of constitutional responsibility. So, my lord, we are urging that you give deference, that, my lord, you allow at this point in time these proceedings to go on before the legislative body and to exercise judicial restraint and not to issue conservatory orders. My lord, exercising judicial restraint, and as I submitted, is in line with the test for the grant of conservatory orders in Peter Gatirao Munya. My lord, again, on the second limb on that question, my lord, they have imputed, the petitioners have said that standing orders number 64, my lord, does not provide for adequate time to do public participation. My Lord, they made that submission. And my Lord, I would like you to look at the same decision of Kariuki Mate, paragraph 93. Because my Lord, standing order number 64 is made pursuant to the provisions of the Constitution. My Lord, standing order number 64 is made pursuant to the provisions of the Constitution. And here, my Lord, the Supreme Court is saying that this standing the orderly conduct of the business, the operations within the legislative arm of government. So, my Lord, I want to submit that these standing orders then enjoy the presumption of constitutionality. So, my Lord, the standing orders provide that if a motion is introduced before the House, the National Assembly, for the impeachment of President and Deputy President, my Lord, the standing orders require that that motion be dispensed of, my Lord, within 7 days. My Lord, within 7 days. And my Lord, that takes us again back to the doctrine of time-bound proceedings. My Lord, within 7 days. My Lord, what that means...
So, which law says 7 days?
My Lord, standing orders, my Lord. So that, my Lord, now going to the Constitution, my Lord, Article 145 on the removal of President, which Article 150 equates, that shall also apply for the removal of Deputy President. My Lord, Article 145, paragraph 3 also says, within 7 days of receiving the resolution from the Speaker of the National Assembly. My Lord, within 7 days from receiving this resolution from the National Assembly, my Lord, the Speaker of the Senate is supposed to commence action, proceedings towards the completion of the removal of, or otherwise, of the Deputy President. My Lord, to consider the motion, my Lord, to commence the proceedings to consider that motion for the removal of President stroke Deputy President. My Lord, thereafter, they only have 10 other days, my Lord, 10 other days to finish the process, to make a decision. My Lord, you can correlate this to Article 140 of the Constitution of Kenya, which requires that a petition once presented to the Supreme Court for the validity of a presidential election must be determined within 14 days. So, my Lord, it's not unique for these proceedings to be determined in this manner. My Lord, there are constitutional policy reasons why that is the case. My Lord, perhaps because this position is important and stability of the nation is very critical, you don't want to keep people in abeyance on who is their president and deputy president. My Lord, the deputy president, when there's a vacancy in the office of president, they're supposed to assume office as president. So, my Lord, because of these constitutional timelines, then one of the reasons one, my Lord, can make is that because of the stability of the nation, you cannot have a vacancy in the office of president and deputy president within this kind of periods. That is why the Constitution, my Lord, has set strict timelines concerning their removal from office or election into office. So that, my Lord, this is now tied on the public participation. So that, my Lord, what happens on the public participation, my Lord, is that whereas public participation is not provided for in Article 64 of the Standing Orders, my Lord, public participation is a constitutional imperative which so many authorities have laid down, and including this court, my Lord. So, my Lord, this constitutional imperative known as public participation must be done within the confines of the timelines which have been laid down. So, my Lord, the National Assembly was required to do public participation, my Lord, within those timelines and not create excuses. And my Lord, that's what the National Assembly did. Public participation within the constitutional timelines. My Lord, submissions was made by Senior Counsel Paul Mwite on whether a response by the Deputy President is needed when you are going to public participation. My Lord, in my view, that is stretching the issue too far. My Lord, what is before the House of the National Assembly is often a motion. And my Lord, the Constitution talks about a motion for the removal of Deputy President. My Lord, that motion, before it is determined, public participation must be conducted. So my Lord, the obligation of Parliament is to ensure that that motion goes to the people, for them to air their views on what they think the motion, on what they think the elected members should do with the motion. And my Lord, sovereignty, they exercise it directly or indirectly through their elected representatives. So, my Lord, there is no obligation whatsoever to send a response to the people, because by that time, there are no proceedings contemplated in the standing orders for pre-impeachment public participation, because there is no motion. It will be speculative to go to the people with a motion which has not been introduced to the House for adjudication. Just like this court cannot adjudicate, my Lord, on a petition which is not before it. People will be talking to the media about the petition, but the High Court will only be seized of that petition when it is brought before it. My Lord, that is very important to distinguish. And my Lord, the efficacy of or adequacy of this public participation considered at this stage of the proceedings. My Lord, the petitioner is inviting you to make conclusive determination on the question of public participation. My Lord, the response from the National Assembly that public participation was indeed done, and the mere fact that it was done, then, my Lord, you cannot consider that on merits at this stage. So, my Lord, we urge that you don't grant the conservative orders. So, my Lord, the application of the conservatory orders will to destabilize the process which is before the Senate. My Lord, there is no timeline, there is no guideline on what happens when the court has issued conservatory orders. What happens to the timelines in Article 145? What happens to those timelines when conservatory orders are issued? My Lord, the doctrine of proportionality in the Mutunga rules require that you exercise some restraint as not to issue conservatory orders at this stage. My Lord, Senior Counsel Paul Mwite talked about gross violation of the Constitution as one of the grounds. He says the motion does not meet the motion for impeachment. But, my Lord, again, in the Sonko case, the Supreme Court has said the role of the court is not to look at the midst of these allegations. My Lord, instead, the High Court is supposed to just look at the process issues. Has the National Assembly complied with the standing orders and the provisions of Article 145? My Lord, if the answer is yes, then, my Lord, you allow those proceedings to continue and conclude. Now that my colleague, Senior Counsel, talked about gross violation of the Constitution, my Lord, allow me to say that indeed, from the motion, the Deputy President, there are serious allegations that the Deputy President is facing. And, my Lord, as I wind up, My Lord, the Deputy President is participating in the proceedings before the Senate. My Lord, that is important. He is participating in the proceedings before the Senate as we speak. So, my Lord, he cannot approbate and reprobate. He cannot participate in the proceedings before the Senate. My Lord, yes, my Lord, the process is going on. My Lord, allow me to quote a document, my Lord, which, because I'm not speaking from the bar. Yes, my Lord. Yes, my Lord. From a response which was filed, which we have filed, and which also my colleague have filed, my Lord, an affidavit, supplementary affidavit by regarding GACHAGUA. My Lord, this is what they have annexed. My Lord, they have annexed a letter from the Senate inviting them to submit a response by 5 p.m. today, stating that the motion is before the House. They were given material which constitute this motion, and they were required to file a response. My Lord, under Article 145 of the Constitution, those proceedings have already commenced. My Lord, what I'm saying is that the 10 days for the Senate to consider that question have already commenced. The proceedings are active before the Senate.
Idea as to whether it's actively engaged. What you refer to a document that he has been invited.
Yes.
Not a document that has filed.
That's correct, my Lord.
So can we restrain ourselves to that point?
Okay, my Lord. I will rephrase then, my Lord, by saying that the Senate has invited the Deputy President,
That's fine.
yes, to appear, my Lord, before it to answer on these weighty allegations which the petitioner says concern gross violation of the Constitution. My Lord, now that brings out a fundamental point. My Lord, he has opportunity in accordance with the provisions of Article 50 of the Constitution. My Lord, he has opportunity to air his grievance in a trial process at the Senate. My Lord, that's a fundamental tenet of the doctrine of natural justice. He has been given an opportunity to come and ventilate his concerns about public participation, content of their motion, the allegations he is facing. He has opportunity to ventilate those concerns in a quasi-judicial process, my Lord. My Lord, quasi-judicial process. So, my Lord, it's better that we allow him to exercise his opportunity to appear before this quasi-judicial process for the trial of these allegations. My Lord, the issuance of conservatory orders will deny the parties that opportunity to subject the allegations against him in a constitutionally tested and compliant process of impeachment. My Lord, the senators act as jurors, as in this case, stroke judges. My Lord, they are required to make up to decide on each and every allegation that he is facing. So, my Lord, the doctrine of ripeness then applies against the Deputy President at this stage of the proceedings. My Lord, his complaint is not ripe for judicial adjudication yet. My Lord, as I submit, as I wind up, the roof is not on fire. My Lord, the courts of the doors of this court have not closed at him to come and ventilate his concerns about the entire process completed. But after the impeachment proceedings have concluded. And my Lord, this is the tenor and the effect of their submit in petition 522 of 2024. Whereas conservatory orders were sought, they abandoned the quest for conservatory orders in 522 of 2024. My Lord, the quest concerning public participation have been